We have one member of the public.
Yes. So welcome to those who are coming. I'm seeing that the attendees list is populating, so we want to make sure everybody has a chance to get on to the Zoom, and then we can start. And we're waiting for one more member whom we think is coming before we take roll. Looks like we have those who are going to come here. So welcome. And to those who are in the public, I'm Judge Erica Yu, and thank you so much for being here. I'm going to ask Christopher if he would please take roll.
Thank you. Bashan.
Present.
Thelmuth.
Here.
Hamilton.
Present.
Kirkmeyer.
Here.
Petru.
Here.
Sarush.
Here.
And you.
Here, thank you. It's good to see everybody. We have a full complement of our subcommittee members, which is great. Just want to let everybody know that we're going to go from 2 o'clock to 4 o'clock today, and we know that Ms. Kirchmeyer has to leave early, and if anyone else needs to leave early, please just let me know. I want to make sure I check in with you before you have to go to see if you have any comments you want to make before you leave. Just a quick recap. One of our first meetings, we agreed that we commit to a pilot program in principle. And then after our meeting with Oshpod and Bonnie Huff, we kind of came away with several different things, including sort of the general principles that whatever we construct should be flexible and have a feedback loop, like, you know, have input of the stakeholders or somehow some evaluative piece. And then last time, Christopher was kind enough to put together a tool for us, and we said this is just a mock-up of what this might look like, but blow it up if you want to. It's not really intended to be what we think the program should be, and we kind of did blow it up. We had a lot of concerns that were expressed, I think, in a really fulsome, healthy way. So what we're going to do now today is kind of drill down, and we have some other thoughts and tools that we think will help us move fast, because we have a report we want to make to the working group on February 26th. And it's a kind of a tight turnaround. We do anticipate we may need to set another meeting. And at the end of this meeting, or maybe at 3 o'clock before some people have to go, I can check in and look to you about guidance for scheduling. So before we do that, I wondered if anyone had any questions, and if not, we'll go to public comments. Any questions or anything that you would like to add, Andrea or Christopher?
Not now. Thank you for asking.
Okay, maybe after public comments, we should talk about the next schedule before we lose some of the members and take care of that right away. So let's go to public comments. And since we do have quite a bit to do, I'm going to ask if we could please limit the comments to 2 or 3 minutes. And I want to thank Mr. Solomon for his very thoughtful letter. I'm sorry we ran out of time last time, but we really appreciate the letter. It was actually circulated to the whole working group and not just the subcommittee, I believe. So anybody wish to make a comment from the attendees? If so, could you please raise your hand? I don't see any hands, but I'll just give a little bit more time, because sometimes it takes a little while to get that hand up. Okay, and hopefully we may have some time at the end, or if you have comments and you wish to be heard, just raise your hand and we'll try to make time. But again, we really appreciate the written submissions as well. And thank you specifically to Mr. Solomon. So just bumping ahead then in terms of scheduling, it looks like we're gonna probably need another meeting. Even if we do a lot today, which I believe we will be able to do, we'll want to have something put together in writing by staff, and then we want to have you look at it and finesse it and finalize it. We need to have certain deadlines met so that we can have things published in a timely fashion for the February 26th meeting. And so we're looking at 2 dates, but both dates don't work for everyone. The 2 potential dates for our next meeting is Monday, February 15th, which is a holiday. a court holiday, and I think a general holiday. And then also the next is February 16th, the Tuesday. So we wanted to check and see if people are open to meeting on Monday, the 15th, or if you would prefer February 16th. But again, not everyone can come on all the days, on both the days.
So Erica, is there a kind of equal number of people who could attend either day, or does it skew one way or the other?
Pretty much it's equal. On February 12th, not a lot of people could come, and that's also a court holiday. So we're kind of looking at the 15th and the 16th.
I'm fine. I'll make either one work.
Okay. Any thoughts? And if you don't want to work on holiday, it's completely respected. I understand that. It's very much actually respected because it's important to have these really good boundaries for our lives and our family. But we just thought we'd check in with you because if we have it on the 15th, it does give staff a little bit more time. They would have to have something in writing for distribution by the 19th, I believe, if I got the dates right.
The 16th in the morning, I have a hearing, so I would not make it if we schedule it then.
I think the time that worked for most people on the 16th was 3 to 5.
Right.
So it was
And
not.
I didn't see your name in the doodle, Steve, and it might have been there after. You might have put it in after I looked.
I didn't doodle.
Oh, okay. So yeah, the time was 3 to 5 on February 16th, which really cuts into staff time, but we want everyone to be there, or as many people as possible. I think Sharon, that was a bad time for you, or am I missing?
Yeah, the 15th is much better for me. Yeah, 16th is not good.
Yeah, I'm sorry.
I can't do the 16th in the afternoon, like at 3, but cannot.
Okay,
I could do any other time that day, or I'm happy to do it on Monday afternoon. I can't do it in the morning. There's not many places we can go these days, just local.
okay, anybody else want to weigh in? What is the other time? There was a second afternoon time on the 16th.
The times we circulated for the 16th was morning at 9:30, noon to 2 p.m. So it's like the lunchtime. And then the final time slot was 3 to 5.
I know, Sharon, that 16th is bad for you, and I apologize, but the 16th had a little bit more, like one more person, I believe, than the 15th. Steve, can you do noon to 2 on the 16th?
Yes.
And Fariba, I think you said the 16th because you couldn't do the 3. Okay, I'm sorry, Sharon, but please, respond to staff when you get the document, and we'll definitely have a lot of time to talk today. So we'll shoot for February 16th at noon, which gives staff a little bit more time.
And Judge, this is Kim. I actually can only make the noon to 1 time. I actually have a meeting at 1 that I have to be at. So.
Okay, thank you so much for letting me know, Kimberly. And please call me Erica, and at least we'll have you for that hour. So, okay, any questions about that? I noticed a couple more people, or one more person came in for the public or the attendees. I'll just give them one more chance if anybody in the attendees group would like to be promoted to make a public comment. They would have 2 or 3 minutes to do so.
As a reminder, the raise your hand button should be in your Zoom window in the bottom toolbar. It looks like a yellow hand.
Okay, nope. Okay, so then moving on, we have this interesting, well, we have, first of all, the last slide that we had last time. And if we could just please pull it up. We're going to
screen.
Share that screen. Thank you. Okay, thank you.
Oh, pardon. There you go.
It's okay. Okay, you might remember this screen. This was the last slide from the last meeting. And these were some of the factors that we thought we should consider in constructing a pilot program. Greg asked a really good question toward the end of that, which is this pilot program going to be a phased in rollout of a program that we're committed to, or is it more of an experimental program that we want to see if it flies and, you know, it's not necessarily something we're committed to. So that is something that framed some of my discussions with staff. Also, we had I think our discussion spent quite a bit of time talking about so many different factors that come into a pilot, and some of those are out of our hands. One is the licensing committees or subcommittees work, and the other is the various subject matters groups. So with respect to the licensing, I think in talking to staff, which is, you know, Leah and Andrea and Christopher, we thought we should sort of set aside the licensing requirements and know that we can go back to the licensing subcommittee. Some of those members are here, and ask them to look for a faster way to get to the ground. Because we heard from the Board of Trustees that they don't want something that's that complicated. And I think what really came out of our last meeting's conversation was there's not so much support for having a program that's a pilot that looks very different from the program that's going to actually be fully implemented. And the reason is there's just too many kind of moving parts. For example, if we have attorney supervision for the initial pilot, what will happen for those people who started and then the other people coming? Do we grandfather people in or not? If we have a lower bar to enter right away so we can hit the ground running, well, how does that justify having a higher bar later for people who want to come in? So I asked Christopher to make that box orange to know that that's sort of something that we're going to have to assume is going to happen, that the licensing committee is going to go look at that and see if they can find a way to allow people to use past experience and past training to help them get into the program more quickly. And so we have to just assume that that's going to happen. The other factors are things that we should be tasked with looking at so that we can give guidance to the working group when we meet with them on February 26th. I asked Christopher to sort of make this location box yellow because some of those factors actually tie in with the entry requirements. And my concern is if we spend too much time on those specific factors, we're going to get right back into the discussion that we had last time about entry requirements and not really be able to spend the time that we want to spend on the factors that should go into a phased in pilot program. And then also I wanted to just thank Christopher again and then remind us that Christopher actually did a really great job preparing this slide based on conversations from our past meetings. He actually had a high fidelity to the comments that we made and captured that. So that means some of what we have in this factors slide doesn't necessarily need to be drilled down on because he might have caught a comment that was redundant for other comments. So for example, in the yellow location box, you might see where it says local court support, which is something that I sort of think might be a factor. And then it says potential for other local partners. That might have been the same idea, or it might be a different idea. So some of these are going to just be words that he wanted to capture to remind us, but they may not all require us to drill down and spend a lot of time on. So with that stated, I wanted to just check in with Andrea and Christopher to see if they wanted to say anything else to set it up, and then kind of talk to you all about which factors should we start to concentrate on. But Andrea, did you want to add anything?
I thought that framed it very well. I know you mentioned timeline, which I think is really helpful. Just that it sounded like, given what sort of a phased approach that we want to propose, as much as possible on the 26th, that we'll definitely need to dig into some of these questions, subject matter, certainly, and the question of geography, if to move it far enough ahead that we can start sort of drafting up something, even though we're going to have another meeting, because I think we need to have something sort of formed to start to dig into in the interim if we're going to kind of have a more polished work product before the 26th. So I just wanted to mention that timing note again, if we can hopefully start to make some decisions about what we'd want to propose with subject area, where we'd start in a phased approach, and possibly that geography question as well.
Yeah, Thank you. Christopher, did you want to add anything?
Nothing to add. I think you framed it very well.
Okay, does anyone have anything they want to say or add? I don't know if Leah or our chair or anybody would like to add anything before we start talking about various different elements. And because we're sharing a screen, I can't see everyone's face, but I'm trying to monitor the panelists if anyone has a hand up. So please feel free to jump in at any time because I won't necessarily see that you want to speak. So please interrupt us. I'm going to turn it to Andrea to help facilitate, but the various different elements here kind of lend themselves to different discussions. We were thinking because we have talked about the subject matter and because the family subcommittee, two of those members are here, did such a fine job in identifying different tasks, it might be helpful for us to start on whether or not we think a pilot should start kind of be initiated with a limited subject matter, and if so, what should that subject matter be? In past conversations, we've said maybe it should definitely include family, maybe it should include housing. There's been some suggestion perhaps it should include consumer debt. So let's start there. On a broader scope, before we drill down to the specific tasks, what do we think should be the pilot's model for practice areas? Should it start with all practice areas or some limitation? And if so, what should the limitation be? And please feel free to jump in and start that conversation. And Andrea, please, can I turn it over to you to facilitate?
Sure. And just as a reminder for everyone, when we've talked about subject area being a way to limit a phased or pilot approach, the conversation we've had today, and I think it's consistent with the internal conversations we've had over the past couple of days, is probably starting with 2 to 3 subject areas, that would start to give us a feel for where this program's working well, but would just feel a little more viable and then starting on a broader. And we're not beholden to that, but I just wanted to remind everyone that 2 to 3 subject areas had been what we discussed, and then those 3 subject areas that that Erica flagged, I think are probably good contenders, although of course we'll want to talk about where we want to land for a recommendation. And I think that Stephen has his hand up. Yeah.
So family law is the easy one. I feel like the family law subgroup has made significant progress in terms of delineating our recommendations to the group as a whole. I think we've got really good, solid ideas about the educational requirements that are coming from the licensing subcommittee. So I think I'm throwing my hat in for family law to be one of the 2 or 3.
I'm not sure if you can see Andrea, but Sharon has her hand up.
Oh yes, hi Sharon.
Hi, I was going to say the same thing as Steve Hamilton. By the way, kudos to Chris for creating such a great visual dashboard, because when I look at family law and I look at all these considerations and I look at the need, especially in that modest means category, so that population, and also the ability of paraprofessionals to get the training and do that kind of work and make a living, to me, it seems like a no-brainer.
And this is Joanna. I'll just jump in to say, I mean, I appreciate wanting to have a full discussion, but I think it has been quite clear that we're talking about 2 or 3 subject areas at most. So I'm not sure we need to talk much further about whether it should be a limited number of areas. I think we've pretty much decided that, although someone should chime in if they don't think that's the case. I concur, family should absolutely, without question, be one of those. Housing is the other one that jumps out at me. There is an incredible need for that as soon as possible. So that jumps out to me as well. As far as whether there should be a 3rd one, I don't know. I don't have a strong opinion on whether there should be a 3rd or not. If so, I would think it would be consumer debt, but I mean, I'd be curious to know what people think.
Mm-hmm. And I see that we have 2 hands up, so perhaps a comment on that.
Fariba?
Am I next?
I saw your hand and then I saw Julie's and then I saw Steve.
Okay, so I think family also from the number standpoint I know that in my office, consistently 90% at least of the work we do has to do with family law. That's just a demand. So you will get the numbers. In terms of other area of law, I think that limited civil could be helpful because there's really not a lot of help available out there. And there'll be people who will have fewer options than, let's say, for even family law. And unlawful detainers, just because, you know, that's going to come online really soon, and we're going to have a massive number of people needing assistance.
Julie?
Yeah, this is Julie. Family law to me is kind of a broad term. Do you have any specific, like child custody, dissolutions, any specific sub areas within that term?
Yes.
Yeah, absolutely. And sorry if that wasn't explicit, but when we talk about these subject areas, they're meant to not recreate the wheel for the works that have already the work that's already happened. And certainly the Family Law Subcommittee, I think, has met the most times and been the most thorough to date on what areas to include. So we can talk that through, or a family member. It's a little nuanced to even just do a verbal overview of, because they've gotten quite specific about what categories would be under that. So whenever we say family law, my understanding is we're relying on that work that's happened within that subcommittee to narrow it down.
And we have their recommendations that will be presented on February 26th, which we'll share that screen soon, or that document soon, and then we can go through those tasks to see if we agree. So anything else, Julie?
No, I don't disagree with including family law at all. In fact, I think most of the other states that have a paraprofessional program do include family law as a practice area. So there's definite precedent there.
Steve has his hand up.
So Julianne, just, we have a very detailed and thorough list of the tasks paraprofessionals are going to be doing. And it's 2 pages at least, and very well fleshed out, including the education we're expecting to be associated with it. So that's why I've said with confidence, based on my work with Fariba, and I think who else is that's on this meeting right now? Sharon's on that one too. We've spent a lot of time. So I'm by the time of the 26th or whenever the meeting is where you're going to go, it's a very detailed proposal. With regards to the ultimate question, I think it should be limited to 2. I think it should be limited to family law and housing. I think if we throw in consumer civil, we might as well roll out the whole program, because family law and consumer civil and housing are the 3 major things. The only thing then we'd be holding back would probably be like collateral criminal and some very limited functions. So that would be my suggestion. Do the 2, housing and family law.
And if anyone's interested, I can bring up the family law list and share it now, or we can wait until later in the discussion.
I just wanted to see if others wanted to say anything about any other topic. It looks like Sharon had her hand up, but thank you so much, Linda. We're going to get there in about 5 minutes.
Okay.
So I'm saying this with the caveat that I am not part of the housing subcommittee, so I don't know what was discussed. There's no doubt that we are all anticipating a tsunami of unlawful detainers, evictions, essentially. And that's a need. The part that I'm concerned about is that low-income tenants who cannot pay their rent, are they going to be able to afford paraprofessionals? And I don't know if that was discussed, but I'm just raising that. And then also putting a plug in for collateral criminal, because that is a clean area that we may want to pilot, and the need is great.
Andrea, is it okay if I call on people who haven't said anything yet, just to make sure that Kimberly and others don't want to say anything?
Oh, yes. No, absolutely.
Kimberly, did you want to jump in here?
Yeah, I mean, from my perspective, I think we should do the largest, or, the one that we can actually get the most response to. And so I would agree. I think that's probably family law. That would be the one that I would hold to. As far as the second one or the third one, I would kind of leave that to the experts, other experts on the panel, since it's a little bit out of my wheelhouse for knowledge of what all that contains.
Okay. And then would staff, including Greg, anybody wish to say anything from staff's perspective who hasn't said anything?
No, I would just say I see there's a hand up in the attendees.
Oh, okay.
I don't know if you want
And
to.
you know, the only thing is, I would say I would agree that if there's a potential for adding a third, I think collateral criminal might be a good one. I think it's relatively straightforward of all of the different practice areas. It's relatively straightforward and low risk.
Mhm.
So it might be a good idea to add that, just because I think there's, you know, high likelihood of great success in that area and then the ability to assist a lot of people.
And Linda, just to clarify, do you mean potentially instead of, let's say, housing law, or as a possible third practice area? Or do you have
As a
thought
possible
in
third. As a possible third practice area.
And then speaking as a committee member, before we go to Mr. Solomon, I definitely think we should do family, and we're going to show that document. They've done so much good work. I'm going to invite us to not really spend too much time on the education piece though, Steve, because that's in the orange box. It's going to have to go back to the licensing group. And I'm worried, you weren't here last time, but we kind of spent a lot of time on that. And I think it took us away from some of the discussion that we needed to have on the details. And I definitely think we should do housing. And I was going to say we should just stick with 2, but then when Sharon talked about collateral criminal, that reminded me that it is, as Linda said, contained, and it's something that could be rolled out, and there definitely is a need. So that if we did a third, that would be my vote.
Are we, remind me, are we talking expungement?
Yes.
That's it.
So
I was
yeah.
going to say, Sharon, you had me at collateral criminal. Yes, I would agree to that.
Oh, I definitely think there's a huge need for that expungement.
Expungement and reclassification.
Yeah.
Oh,
37.
Did you say there's not a huge need for REBA, or do you say there is?
oh no, there is. There is definitely a huge need. Yeah.
And Steve, what were you saying? We had you at collateral?
Yeah, well, as soon as you said collateral criminal, I go, yeah, that actually is a nice fit to do. And so I think that makes sense. Family law, housing, and then collateral criminal.
Okay, sounds like we have a little bit of consensus. I'm going to ask if Mr. Solomon would like to be promoted and give him about 2 or 3 minutes. But I'm sorry, we do have lots to deal with today. So I'm going to ask you to stick to 2 or 3 minutes, Mr. Solomon. And I'm looking forward to hear what you have to say.
Mr. Solomon, I'm enabling your mic right now. Okay, you're ready.
Thank you. I will be less than a minute, and I appreciate your circulating my letter. Just quickly, I just wanted to echo Sharon's point about taking into account ability to pay. And I think, yes, family law number 1, I think the question of what's 2 and 2 and 3 probably requires some more exploration of the question of what clients are able to actually pay something, and whether housing therefore can be included in that. Obviously, I very much understand the huge need for both that and consumer debt. One thing you might also throw into the mix is state administrative practice. So Arizona went with family law and state administrative practice as 2 of its initial 3 or 4. So that's like unemployment insurance appeals, disability benefits. These are obviously people who have need. That's why they're relying on these benefits. But because they may, get these benefits, they may also be able to pay something. And it's kind of a relatively clean area in the sense that, you can learn how to do these hearings in front of administrative agencies, and then you can do them in a few different areas. That's all. Thanks so much.
That's a great point. Thank you so much for that comment. I appreciate it. Okay, so can we please show the housing recommendations, the draft recommendations, and we got to consensus pretty quickly. We have some other potential like limited civil, consumer debt, and then income maintenance is what I think we were calling the state administrative practice. Okay, thank you, Christopher, or Linda, whoever's sharing it.
Turning it over to Linda.
I'm sharing the family law subtopic and task recommendations. And there are a few other subtopics that we're still building out, that we're working on some of the non-domestic violence, restraining orders, civil harassment, workplace harassment, and elder abuse. And we're gathering information about those, as well as conservatorship and guardianship, not including a conservatorship or guardianship of the estate. And we're going to be bringing more information to the subcommittee, but this is what's been done so far.
Okay, thank you. Andrea,
Is this big enough for everyone to read?
we're gonna have to probably go block by block because it's a multi-page document, so it'll be hard to put it all on one screen.
Yeah, may I ask if someone from the family law subcommittee can just, we don't have to, I'm sure the nuance of this is more than this meeting has time for, but if you could maybe just quickly kind of talk us through the high level of what's contained here.
Steve, I'm happy to use
more context than I do.
if you want to do it, or I can do it, up to you.
I'm good to go. You want me to do it? All right, I win. So what this list did went through the tasks that typically any family law attorney would handle. We kind of mocked or followed the order of issues that were raised in a dissolution petition and then added additional issues. So with regards to in divorce actions, we're expecting paraprofessionals to be able to file an action for legal separation, divorce, or nullity. The ones that we are proposing to exclude are ones that require more technical proof and or probably expert testimony or professional testimony. And those were annulments based on incest, unsound mind, fraud, force, or physical incapacity. We included paternity actions as being an area for paraprofessionals. We're proposing to exclude 2 areas of paternity that are more complex and we think would be better suited for attorney representation than in paraprofessionals. And those are cases where you have competing presumptions regarding paternity, biological father versus nurturing father, biological mother versus nurturing mother, or even more complex 7612C actions. That's where we can now recognize more than 2 parents for a child. And it's up to the discretion of the court. Those are not frequently brought actions. I think I've handled 1 since the statute passed, and there wasn't an area that we thought we should be included. Summary dissolutions include, petitions for custody and support absolutely include domestic violence restraining order applications. We are requiring or suggesting that there be not only DV education, but we're also including a suggestion for trauma-informed education too, which is being parroted by the licensing subcommittee, including all issues of child custody and
Sorry, Steve, I just want to point out that we separated other violence prevention actions, and those are being worked on separately.
Correct.
We're still in our group, but worked on separately. So this is just DV.
Include child custody and visitation, include assisting grandparents with filing their own independent actions for visitation with their grandchildren. The 2 things that we excluded are areas that are highly technical and not usually dealt with by the standard family law practitioner. We usually bring in experts. Those are Hague Convention or international child abduction issues, as well as international or interstate custody disputes under the UCCJEA. We included all aspects of child support. We included almost every aspect of spousal or domestic partner support. The one exclusion that we're going to propose is that a buyout of non-modifiable order or step downs in a permanent support order involving a long-term marriage, one more than 10 years. We carved that out as an area. Going to property issues, basically allow them to do all of the property issues. And I think we're going to overlap into discovery areas. This is probably the version before our meeting yesterday, Linda. But basically allowing the paraprofessionals to work on all the forms related to preparing for trial and at trial, or at requests for orders regarding property issues, preparing disclosures, referring out for appraisals and other expert work. Items 4 through 9, we're moving to a separate discovery category. And basically we're agreeing that suggesting a paraprofessional can do all discovery, excluding depositions and excluding expert witness depositions by nature, or motions to quash or compel related to depositions, and also excluding expert discovery from the scope. But in terms of sending form interrogatories, special interrogatories, document requests, those are all included functions. And specifically excluding quadros, those are a bane for family law attorneys and just not an appropriate area for paraprofessionals, including post-revision transfer documents, still making sure that the paraprofessional can help with getting the deeds and the car registration switched over. For discovery, we went over that one. Quasi-marital property. This involves void or voidable marriages, and it's just a highly technical area that we would want to exclude, including attorney's fees requests, including restoration of foreign name, any venue or jurisdiction disputes that are not specifically excluded. For example, the UCCJEA ones that I just mentioned would be within the scope of the paraprofessional work, including marital settlement agreements. I brought up yesterday a suggestion from the Family Law Executive Committee for the California Lawyers Association, making sure that the paraprofessional prepared MSA identifies that it was prepared by a paraprofessional. That covers that category. Is that the bottom of the list? Or I think we got more, don't we? Okay. Post-judgment modifications, because those are overlapping, for example, the same issues, custody or support. Registration of foreign judgments included, excluding premarital or postmarital agreements, and the rationale there being, again, that's a highly technical area. You have area attorneys that specialize in that, and that's one of the most difficult. You basically end up doing double the work in most prenup cases because you end up having to try the prenup first and then you do the trial. Putative spouse claims and Marvin palimony claims, those are non-marital claims, and those are actually brought in civil court, so we're excluding those. And then enforcement, all of these different forms of enforcement, appointing an advisor so the clerk can sign a deed if the other party won't, filing requests for order with the court to assist in enforcement, seek work orders, debtor's exams. The one that we excluded was contempt because of a quasi-criminal proceeding. And I think we included wage assignments. Is there anything else below that, Linda, or is that it? There we go. Writs of execution, yes. The filing of the lien or the lis pendens, I didn't bring that up yesterday, but that is routinely done currently by staff, not by the attorneys. And then assisting people in responding to DCSS actions, even though both parties are supposed to be represented in a DCSS, they're there for the child, so to speak. There are people that need assistance when their licenses are being threatened because of DCSS. The child welfare and juvenile dependency cases is still a work in progress. We had information yesterday, so I'd say we don't have a recommendation, firm recommendation there yet. Same with adoptions. We've had discussions, but those aren't finalized. And then finally, allowing the paraprofessionals to assist with alternative dispute resolution, including settlement negotiations. And, you know, once we actually get to go to court, doing the meet and confer at court, or if a court's set up now to be able to do breakout rooms in Zoom. And then the footnotes all had to tie to the things comments we were making about education that we would be expected, required for these different duties. So we're making sure that there's people that are instructed with regards to domestic violence and get domestic abuse training and that type of thing. And for example, footnote 4, if they're going to do support issues, they need to know how, be trained on how to use both the state calculator, or if they're the better one is actually a private one to be used to so master. So that, in summary and quick brief format, is the working recommendations of the family law group.
Steve, did you want to touch on the contours of in-court representation, which we discussed this week?
Okay, yeah. So the other thing is, I reported to the family law subgroup yesterday that I had a meeting with the Family Law Executive Committee for the California Lawyers Association. They were very supportive of how wide-ranging the proposal currently is from the family law section. They gave some good feedback on some kind of technical changes that we worked into it. The one thing that was clear is that I know that their position is, and this will be the position I'll be advocating for, is that the paraprofessional can sit at council table. They can prompt the party in terms of addressing issues they may forget to address. They can assist the party in introducing exhibits and responding to judicial questions. But for the family law section, there's a bright line, no responding to the judges or participating in the hearings. And I know that that's not what I think Justice Petru had suggested, that we allow them to answer questions from the officers. And the feedback was, it's a slippery slope. Number two, the way that you answer questions is advocacy, in my opinion. If a judge is asking me a question from the bench, I'm arguing. You know, I won't be using an argumentative tone, but how I respond, what I address. I try to think of an example today before the meeting. I was going, you know, if they ask my client the question, you know, how many children are there? Well, there's 2 minor children, but my client's also supporting the adult daughter that's at Cal Poly right now, right? Not really responsive to the question, but what am I doing? I'm advocating for my client. Look, Judge, my client, even though it should be irrelevant to support, is out there supporting their adult daughter. That's the thing that my section's worried about and my entity's worried about. And so it's our proposal, my position in advocating for my constituency group, that we not allow the judges to question the paraprofessionals. I also have another concern too, which is I think that there are some judges that nobody that's involved with this working group, but just having appeared in probably maybe 20, 30 different courtrooms over my career, I think that there are judges that wouldn't limit themselves to just the questioning. You'd hope that wouldn't be the case, but it's just a slippery slope in our position.
Thank you for talking us through that. So yeah, to the question earlier, yeah. So again, that's the same universe that's adopted on the meeting on the 26th that we would be contemplating in including family law in a phased piloted approach. And it sounded like there was near consensus on the family law being one of the topic areas.
So then my question is, on the list of what's included or excluded, do we think we should just fully adopt the recommendation of the Family Law Subcommittee in a phased in pilot, or do we think that we want to limit some of that as we look to the pilot?
I think we should test everything. Let's find out what's because I would think that our best way to get information is when we're in the pilot program phase and we're closely monitoring everything that's occurring in court. If there's going to be a problem with paraprofessionals helping spouses in a long-term spousal support argument, I want to see that in the trial program, because that might cause us to then change the scope of practices.
What do other people think?
And I think you will be able to further assess the needs and kind of pinpoint the areas that the need is the highest, versus if you go in and say, okay, we're just gonna roll it out on starting divorces, starting custody cases, and maybe child support, and leave everything out. I think just lay it all out, see who the consumers are, where they come in most. I can tell you anecdotally from my office is definitely starting cases, whether it's divorce or custody visitations, definitely starting cases that never slows down. And that's our number one use here, or the customers coming for that. That's those sort of tasks. But I do think that you need to roll it out and just take a look at what happens.
What do other people think?
I agree. I don't see any reason to limit it.
Julie, do you want to say anything?
I agree as well. That's a very detailed list, and I think we should test everything.
Kimberly?
I agree as well. I think, again, since it's a pilot, we need to do the whole, even though it's a limited scope, that whole scope.
Okay, I'm sorry, Sharon, I just saw your hand.
Oh, I was going to agree as well, but this also brings up a question that Justice Petro mentioned last time, and I think it was in Mr. Solomon's letter as well. What are we going to be communicating to the paraprofessionals in terms of what the pilot looks like? Is this going to be a pilot that leads to a full-fledged program? Because if we want folks to sign up, I think that we need to make that decision, and that ties into what we're talking about here.
Do you mean as opposed to one that looks like it's only good for a certain term and then it would sunset?
Exactly.
Okay,
Exactly.
and that's a good question, and that is something Greg raised too. So last time, were you going to say something, Fariba?
I know I just spoke, but as to that point, I just, the amount of work that's going into this project, it is a pity if we just roll it out for 1 year, 2 year, 3 year, whatever it's pilot period, just to see if it works. I mean, I'm on the regulations committee. And I was just really working hard. All of you are on different committees, and I'm just saying, let's commit to this thing and use the pilot to learn and to identify gaps and to improve the program when we completely roll it out. I'll get off my soapbox now.
I felt like we ran out of time last time, but that's where I saw consensus building. So let's just check in with everyone. Did Fariba and Sharon sort of express where everybody is in terms of more of a consensus that, yeah, we think that this program should be a phased in implementation, but that it is not rolling so that it'll be studied and then maybe sunsetted, but this is the program, but we're going to bring it to scale. We're not scaling it 100% as we launch it. Are we at all there?
Yes.
Yeah.
Yes.
Okay.
But I would just add
Let's use the pilot program to fix problems, not to find ways to get rid of the program.
Okay, Andrea.
Oh, yes. No, to that point, I was just going to add in, there was a comment earlier that Erica made about, or someone made about flexibility. And part of that is, just because it's phased versus, it's a 2-year cycle and then maybe it ends, it's sunsetted, doesn't mean we don't get data and learn from what's going well, where there might be challenges, right? So I think that goes back to that flexibility piece. So we can still use that time period to learn, to get information, to figure out if there's things that need to be adjusted. Maybe there's something on that list that comes off or gets added on based on what we learn. So I was just adding that I do think that data and some feedback is still part of a phased process.
You're right, because we want to make sure that we remember, we learned that flexibility and a feedback loop, some type of evaluation or input from the stakeholders is going to be something that should be an umbrella issue that's important. Okay, so I think we're making good headway. So I think we have consensus about full-on family launch, and that this is a sort of taking it to scale as opposed to a pilot, like it's a taking it to scale approach. But I want to just make sure staff has had a chance to weigh in as well. So does anybody want to be heard that hasn't said anything? No? Okay. So let's look at the housing document then, if we can. It's not as detailed, and it may be that we just have to say we want to adopt this with housing and then kind of go back to the housing subcommittee to give us a little bit more details, because it's not as detailed as the family subcommittee's work.
Now I can share the Linda, the document that you sent to me just before this meeting.
Thank you. And then we might want to queue up the collateral criminal, which we hadn't talked about this morning, to give you a heads up. And Andrea, I hope it's okay that we're sort of co-facilitating.
Oh gosh, yes, that's better.
Okay.
Thank you, Christopher.
And I'll zoom in a little bit.
Okay.
That's probably too much. How does that look?
That looks good. And we're so lucky because Julie was on the housing committee, subcommittee, and I'm wondering if she wants to sort of just explain their recommendations so far.
Geez, I haven't looked at this in some months.
I'm sorry, you're right, because I don't see the date here because it's from June. So if
It was June 30th.
Yeah.
I can tell you that what we mostly did was try to document need, and we used the Shriver project data and tried to extrapolate that in terms of need for some representation usually by unrepresented tenants in unlawful detainer actions. So I think we were pretty much able to demonstrate need, even though neither the Judicial Council nor the State Bar collects data on that, on the number of self-represented people in UDR, unlawful detainer actions versus represented. But there's a consensus that landlords are generally always represented by attorneys, and tenants are almost never represented by attorneys. I believe we recommended that unlawful detainer be a practice area that paraprofessionals should be able to practice. And I think we were also looking at some quiet title actions. And we didn't delve deeply into that, but we were thinking of simple ones where the need for a mechanic's lien, for example, has gone away. And those things just stay on a title unless they are affirmatively removed. So we were looking at that. And Sharon asked a question a while ago, whether we looked at the ability to pay. We did not. We did not look at that issue. We just looked at the area and the demonstrated need for paraprofessional assistance in that area.
And that makes sense, because when in this time frame where this memo was written, we were looking to see what should be in and what should be out, and we were exploring the wobblers and things like that. So we weren't really looking in that level of detail. Is the housing subcommittee going to be meeting again? And Linda has her hand up.
Yes, we are going to be meeting again. I don't know when. My calendar is ridiculous, but yes, we are.
Linda, did you want to say anything?
Yes, I just wanted to confirm that this recommendation went to the working group at the June meeting, and there was actually a vote, and there was a decision to include evictions and unlawful detainers, to include homeownership issues related to clearing title, but not quiet title actions.
Okay, thanks.
And the plan at this point is for the subcommittee, and we have 4 meetings of the housing subcommittee scheduled between now and the April meeting, with the idea of doing the build out similar to what was done for family law and presenting that to the working group at the April meeting.
Since this group's consensus on the family was that we don't want to have a piecemeal rollout of a subject matter, I'm thinking that that's what our view would be on the housing, and so that whatever the housing subcommittee recommends will probably be what this committee thinks should be included in the pilot. Is that a good read on this group? Because I mean, that makes our discussion here a little easier, but I want to make sure that's our read. So just I see a hand up, and that was Linda's. So anybody want to say anything on that? What do you think? Cynthia, I saw you unmuted yourself.
Oh, I was just, so much consensus today. So that's a good thing. So it sounds like generally people are comfortable with these broader categories that have been identified, and also imagine that we would defer to the more developed specifics once that committee meets again.
And that we would recommend adopting the whole program for housing and not piecemeal.
Right.
And anybody object to that? Okay.
Oh, I think Sharon, did you have a comment on that before we turn to something else?
Yeah, just I'm not part of the subcommittee, but I would just urge the subcommittee to really look at how a paraprofessionals program in housing would tie into the Shriver and Civil Rights Council initiatives, because there's a lot happening here in LA. There's been funding. There are a lot of organizations that are doing this kind of work for low-income tenants for free, and just having a robust cross-referral program, having conversations about that would be great. And then if you haven't discussed it already, deciding what paraprofessionals can do with regards to in-court representation. It's going to be a very important topic.
Yeah, Sharon, that's a good point. And with the right to counsel, it's complicated too, because for example, this is very high level, but LA was going to have right to civil counsel and housing kind of roll out, LA County. And then with COVID, my understanding is that's maybe didn't roll out in the same way that was anticipated. And in San Francisco, there's more or less city funded right to civil right to counsel in housing cases and no income limit. So there's a whole income interplay with how right to counsel is being handled. And obviously it needs a much more detailed analysis than that, but just noting, I think that's a really good issue area to point out that would have to be thought about.
Yeah, and then furthermore, are we talking about representation for tenants or landlords or both? Because I could see landlords seeing this as a low-cost solution, whereas a lot of tenants might not be able to afford this. So just thinking about that, and are we creating more lopsided cases? So thinking through the implications of that.
Can I also add that having done that calendar, sometimes there are landlords who, they're an elderly person who rented a room in their home and now they can't get rid of a tenant who's terrorizing them. And so I don't think we should exclude landlords just completely, but just sort of think of a barometer of pairing people. And also the housing subcommittee was Julie and Ira, which was great, but I'm wondering, is that the continued housing committee or have other people joined?
Other people have joined. I'm just pulling up the document. Right now we have Julie, Judge Harper joined, Amos, Fariba, and Ira. So it's a robust subcommittee.
Good. And then sorry, Fariba and
I just wanted to, I'm sorry, go ahead.
Sorry, Linda. Fariba and Julie have heard what Sharon said, so I'm sure that, and so has Linda, and Leah, so you'll remember it when you have your talks. Sorry, Linda.
I just wanted to, in terms of what Sharon was saying about ensuring that people are aware of these possible free alternatives like Shriver, the regulation subcommittee is developing recommendations for rules for mandatory disclosures. Among them is a requirement that the paraprofessional advise their clients of lower cost or free alternatives that are available. So we can be very specific about that. And the subcommittee can be directive to the group that's working on the rules to ensure that that's included. And Greg is working on those topics. I don't know if you have anything to say about that, Greg.
We haven't covered that specific topic in regard to the rules at this point, but that's a good point.
Can the regulation committee also think about disclosures for people with language services, like what other services are available for people in their chosen language?
I think we can broadly address the topic of making sure that they advise their potential clients of all kinds of resources that are available.
Yeah, Amos and I have drafted those documents. I haven't had a chance to really discuss it at length, but we have another meeting coming up on Thursday,
yeah. And we'll have to drill down. We'll have to get specific about what kind of disclosures. It's going to really be dependent on where the paraprofessional is practicing and what. It's hard to formulate that into a rule without providing additional guidance to the paraprofessional. What exactly am I supposed to be disclosing in this situation, and who is operating in this field as of this month as opposed to last month? It's
yeah, it could be general though, that they're basically general admonishment that or advisement or disclosure that there are local resources, free resources that may be available to help you with your issue. Sure. And here's, maybe a general website or something like that. We can definitely drill into that.
Yeah.
Okay.
I know this is an aside, but I've expressed before that sometimes people feel stuck because they think, okay, this person speaks my language, so I have to go here, and they don't know they can go elsewhere.
Mm-hmm.
But
no, I agree.
Yeah, anything else on the housing piece? So then Sharon and I are going to be put in the position you were, Julie, of bringing up the old memo on collateral criminal, because it's been a while since we've looked at that.
No, but Linda, do you have the slide from the presentation that Justice Pachuca to the board? We can't hear you, but that's a really nice summary.
What was that a summary of?
Sure. Let me bring that up.
Criminal.
Oh, great.
What's authorized is it's also infractions. I think we need to.
I'll bring that up right now.
Thank you.
Seems like a whole lifetime ago.
Yes.
We decided on this.
During the pandemic, so much happens every day, especially with the election. It really feels like it was 10 years ago.
January was definitely a whole year's worth of
It was.
events.
Yeah, my hair got grayer.
It seems to be frozen here. Having trouble opening it up.
But thank you. We'll be patient. We're accomplishing a lot. I think Andrea, Christopher, and I are really happy with the pace that we've gotten things done by. Oh, it's 3 and we lost Kimberly and I didn't get a chance to check in with her. Sorry. Fast.
Completely. Hello?
Okay.
Oh,
Yeah.
okay. I completely froze there for a moment. My whole computer froze. So hopefully this will work now.
Do you have it, Linda? I have it up. I can share it.
Okay.
Maybe Sharon or Judge you.
I think opening PowerPoint is causing my computer to freeze.
Okay. Can you all see my screen?
Yeah.
Yes.
I'm not sure if Sharon or I saw this before, but Sharon, would you like to talk about our work on collateral criminal, or would you like me to do that?
This comes from the memo. Judge,
yes,
we can change. Yeah.
Do you want to jump in, Sharon, or would you like me to?
Sure. So we spoke to a whole bunch of subject matter experts, including Peggy Stevenson, who has a very established program in Santa Clara County where she has a class of undergrads that do this kind of work. We also spoke to Judge Gaffon and Nora Cregan, and we basically decided that all these tasks that are highlighted are appropriate for paraprofessionals, in that these are high need areas. It's something that a paraprofessional could be trained to do. If you also look at the program that Nora is using, which is the TAP program, it's the use of technology to streamline a lot of these tasks and to make it easier. And this covers really both expungements and reclassifications. And as Judge Gaffon said, you have several bites at the apple. So the risk of harm is not that great. So I'm sorry, this has been like a long time and I'm painting with broad strokes. What am I missing, Judge Yu?
Actually, I was sitting here in awe of you, Sharon, thinking what a great job you were doing without any notice that you were capturing really all the salient points. Okay. You did a great job.
Thank you.
So I know that the collateral criminal group is meeting again, and we'll probably drill down a little bit more. And knowing that our group is thinking we should, the pilot should embrace whatever the subcommittee's recommendation is for the subject matters. I'm assuming that's what we'll do when the collateral criminal drills down a little bit more. But Linda, did you want anything, or Andrea, did you want to add anything?
I just wanted to add, it sounded like there was near consensus around family law and housing, and then some general leanings towards collateral criminal being the third if we add a third. But I just wanted to loop back on the question to confirm, does it seem like there is a leaning towards having a third if it's collateral criminal?
That's a good loop back. So anybody object to us having a third? And if we do have a third, do we think it should be collateral criminal? Thanks, Andrea.
I mean, I think, again, the weighing factors, the more we test, the more information we have, or test in a phased approach. But obviously, we also, it's a bigger program. Every subject area we add some complexity, especially if we're going to be trying to get data in this phased process. So
Julie has her hand up.
I don't really object. I just wanted to ask a question. I need my recollection refreshed. Did we at some point have utility shutoffs on our list of practice areas, or included within some other larger practice area? I'm reading a lot about water shutoffs.
Leah, looks like you wanted to say something. Oh, can you unmute yourself?
You're muted, Leah.
She can't unmute because she's sharing.
I was lost on my Zoom screen. I needed your guys' help to find myself. Yes, utility shutoffs is under civil. Is that right, Linda?
I think I remember we talked about that under civil.
It's still remaining. It's still remaining there. That subcommittee is going to resume like housing after the February meeting.
Okay.
Any other?
Also, earlier in this conversation, Leah mentioned that under this collateral criminal umbrella would be something called reclassifications. I don't know what that is.
Prop 47, the reductions, but Sharon, go ahead.
Oh, okay.
Yeah, just Prop 47. So non-serious, non-violent felonies. There's a whole list of them, and what you have to do, and you can reclassify them into misdemeanors.
Thank you.
Yeah, of course. Any other questions or thoughts? Okay, so we're buttoning it down, so that's good. So I think, do we all agree we've done our work in the subject matter areas and we can move on to some of the other factors?
Yeah, and I would just agree, just outside of facilitator role with what Sharon said earlier, that collateral criminal, I do think tends to be a bit more, the process can be a lot more contained and straightforward than some of these other subject areas. You know, I know on the pro bono side, we used to do a lot of this work in the context of a clinic that Nora Creek, and who I know is one of your experts, ran. So I thought that was a good suggestion that we look to this as the possible third subject area.
Thanks, Andrea. Then maybe can I ask Christopher to please put up the first slide, which has all the various factors so we can remind ourselves and we can choose another factor to discuss.
Sure. Let's see.
Maybe
Leah's still
Leah
sharing her screen. I might be able to just.
Leah has to stop sharing.
There we go. Perfect.
Thanks,
Leah.
And Erica, I defer to you, but it strikes me that maybe the other biggest piece of what would be limited in a phased rollout is the geography question. Yes. But I think that is going to be a little more complex.
Yes, I definitely. In our pre-meeting, we were thinking we should do subject matter first and then go to geography, because geography is going to be more complex, partly because it loops back into the entry requirements, which we're trying to, put a pin in it and say we trust that the licensure subcommittee is going to work on that. So we might have to make a certain number of presumptions. We might have to say, let's look at geography, but just assume that there's going to be enough people who want to do it there, enough people who need to be served there, enough support in the education institutions there. Because if we start to delve into some of that other stuff, we're going to cross over to the entry requirements and the licensure committee, but also we're going to cross over to places that we don't yet have the information. Leah has really tried to find out where, the certified paralegals actually are geographically in the state, because they're not registered. There's no easy place to go to find out who they are and where they are. But we'll try to get that information. But if we wait till we have that information, we won't be able to put together our report for February 26th and state all these things and make these recommendations.
Erica,
Yeah.
I could just jump in for a second. I completely agree with you that we should stay away from these things in the orange box.
Mm-hmm.
The only thing I want to say related to education is not the substance of it, but simply to say that in order to get education partners on board, we also need to have an adequate, potential student body. And so whether we are geographically limited may be something that may or may not, but might impede our ability to get the education piece up and running, regardless of what those specific requirements are.
Yeah. So it is going to be a little bit more complex of a conversation, but just closing out what we have just said, I'm keeping in mind that some of these things can be done remotely now, and the courts are letting people e-file now, and it's just going to be a little, like geography might be a little bit less difficult than we are thinking it could be. So I'm going to turn to Andrea and Christopher to see if they want to say anything else about geography before we start talking about it in more detail.
I would just add, just as a framing issue, that geography, I think, is the other most obvious way to limit a phased rollout besides subject area. But there is that fundamental question, of course, do we want to limit by geography at all? And I've heard people voice kind of both opinions. So just again, as a framing place, I know that that question's come up.
That's a good place. That's a good way to start it. Christopher, did you want to add anything?
The only thing I would add, and this might be a rather small influence, is if the pilot ended up incorporating really rigorous data collection mechanisms for evaluation, some geographies might be slightly easier to stand up evaluation mechanisms. For instance, if we wanted the local courts to provide feedback about their experiences with family law legal paraprofessionals and sitting at council table. Maybe some courthouses are better equipped to be able to do that than others.
Yeah, and then on that issue, if we chose an area where there's a court with a judge on this working group, there might be more support. So, like for example, Judge Wiley said that maybe San Francisco would be willing to do this and might be a good place for that. And so it might make it easier to collect data. And then we could look at the self-help centers and see if their self-help centers are ones that are willing to work with this group. And Fariba has her hand up.
So I think that maybe we can sort of combine the best features of both, like rolling it out statewide, and then kind of in certain areas, reach out to local courts and just other justice partners that would help us assess the program. Like let's say LA always gets all the pilot projects because they're so huge. So it could be LA, could be, let's say, our county. We would reach out to the family law judges and, ask them to keep track of something. I don't know, definitely my office. Or we want to reach out to some smaller counties. If we roll it out statewide, but then only reach out to certain counties to collect our data, then I think we get best of both worlds, sort of.
Okay, Sharon.
This is again where like Bonnie Huff is a great thought partner because she knows all the court systems. That was my first point. My second point is that some of this cuts both ways. So some of the areas that I think about throughout the state that don't have, maybe the best court systems or the most robust self-help centers or even a lot of legal aid organizations are these justice gap areas. But sometimes those areas need these services the most, but you just don't have a lot of oversight or partners.
Yeah, that's why it's complex. Steve had his hand up.
I really want to push for some small county data to be collected and reviewed, whether we do a full state rollout or partial. I'm going to promote Central Coast and trying to get information maybe from San Luis Obispo County and at least northern Santa Barbara County.
And then Judge Harper is from Trinity, so we do have some representation from small.
And I would just add the note, because now there's a conversation about, even if we do roll it out statewide, would we focus the data on certain localities? And just the one note I would add, not advocating for one way or another, but the note I would just add is that the data and observation is part of one of the safeguards that, anything less than a full rollout allows us to have. And so we would just want to think about the other safeguards in areas where maybe we're not studying as much. And because that studying it, even if we're not talking about it in a, are we sunsetting in 2 years context, is going to inform if things are changed, tweaked. We talked about flexibility. So if there's certain areas that we're rolling it out, but not taking as close of a look, I just think we need to think about the safeguard. So I'm just wanted to add that.
What I heard when I was listening to what Fariba said, I was thinking if we did a statewide rollout, that we would have instruments like documents that we would be able to use to collect information, but that some of the pockets might be ones where we could drill down more and actually ask the court to work with us or the self-help center to work with us. But I was thinking that we probably will want to do like a feedback loop with all the various counties. That's what I was sort of how I was taking it.
Yeah, and as I believe everyone knows, Shriver was limited by subject area and geography. And I believe that's one of the reasons they were able to get robust data. Not that we're trying to replicate that, it's a different project for a lot of reasons. But I know Bonnie said the data was a pretty big lift. And so we would have to think about how ambitious we're being if it's statewide and we're trying to collect data. So just, yeah.
Yeah, and I think Bonnie said that that was an expensive process too. Yeah. Steve, did you have your hand up? Oh, okay. So, what do we think? Let's hear from some people who haven't said anything yet. Julie and Justice Petro. Julie.
I need to think about this more.
Okay.
And when you say think about it more, sorry, are you meaning whether it should be limited geographically at all, or how it should be limited geographically?
Both, all.
Yeah, and likewise, I don't have a strong opinion on this. Part of the reason that I don't tend towards limiting it is I'm not seeing the obvious way in which to do so. I appreciate what Erica said about the fact that it's true. Like, we have some judges that are involved with this group that would help facilitate, but that's kind of by happenstance, except for the fact that I will say that for the folks that I added onto the group in December, I specifically chose 3 very different counties. You know, San Diego, Trinity, and San Francisco are 3 very different places. And so I tried to represent some diversity, but I don't know. It's just not obvious to me how to limit this, which raises the question of whether to limit it at all, understanding. And again, you know, someone raised the fact that some of the counties in which it may be the most difficult to implement are also the counties where there's the greatest needs. So it's one of the many reasons that I find this a difficult question.
Mm-hmm. It is. It's more complex. What does staff think?
Personally, my inclination would be to have some geographic limit, just because it's such a big state, and I wanted to feel like we can be doing some data evaluation as a safety guard, but I completely understand the practical challenges of that decision. And as Erica pointed out, you know, now that a lot of things are remote, it's maybe a little less meaningful too to say it's just in this court, but the paraprofessional could be from anywhere. So yeah, that's my leaning, but it's not a straightforward question.
Thanks, Andrea. Sharon has her hand up.
I'm so wondering, in thinking about geography, how economics plays into it. How does cost play into it? Are we going to get more paraprofessionals to cover the cost of this if we're wider spread, or is it going to be more of a costly program if we are widespread in terms of evaluation and what Bonnie said about the cost? So economics has to play into this.
Would we be able to get some of this data that would help us analyze that question?
Well, I think we can kind of assume the answer to that question, because it's a great point, but like, the fewer number of licensees you have, the less licensing fees you're going to generate. And so the more licensees you have, the more you're going to generate. And there's a certain economies of scale in setting up the data collection mechanism, whatever the licensing infrastructure is going to be, where, you know, the incremental cost of going from 10 to 50 to 100 licensees, it's not going to grow in the same proportion. And yet you'll get more and more licensing fees to cover those costs. So I think that is a good point. I mean, I've been assuming that this program is going to be funded for the first several years through some kind of loan from the State Bar General Fund to the program, akin to the structure Kim has shared with us for new DCA boards. So, you know, I don't think there's any way that it's going to be self-supporting during a pilot phase, even if it's statewide. But it's a good point.
Anybody? And I had asked if staff wanted to say anything, so I wasn't sure. If you haven't had a chance to jump in, please feel free to do so.
Well, I would just say, just following up on my comments, that I think my natural preference would be some kind of geographic limitation, ensuring there was a really good diversity of geographies represented. But I am very concerned about not having sufficient licensees. And I think that concern has to be paramount, because the program really, you know, it will not succeed if we don't have enough people applying to be triple LTs. And so that's just a huge concern that I have.
And do we think we need more data, or can you, because you said you're trying to get the data?
I'm trying to get the data on the certified paralegals, and all that I would get, I mean, it's not going to be that great, because the data I would get, which I'm not able to get so far, is for those who attended an ABA certified paralegal program, any data that the schools provide as to their graduates. So, I know there are 34 ABA certified paralegal programs in California. So we could certainly look at where those are. We could look at which ones pre-COVID offered a distance option. But I don't know if these schools are reporting like the zip codes of their graduates. That would be optimal and ideal, but that doesn't even necessarily tell you where these folks are statewide. But that's the data push on the certified paralegal side. Again, on the JD side, that's easier. When I say easier, it's the zip code of folks who did not pass the bar exam.
Anybody else want to say anything? Okay, I see a hand up with Sharon.
Oh, I also wouldn't discount the fact that a well-marketed program might also attract paraprofessionals who, like, let's say they live in San Mateo County and the program's not there. It wouldn't prohibit them from developing a practice in Santa Clara County if that was where a pilot program was. I think that sometimes that's what happens in markets, is that people become crafty and they do what they need to do to develop their businesses. So just thinking about that too.
Thanks. Steve?
I was thinking about the issue of whether we do a limited area and then that potentially impairing the success of the program because we don't get enough applicants or participants. But if we're committed that the pilot program is to fix the problems, not to be a whether we're going to keep it or not analysis, then I'm less concerned about how many we get at least in the first school, because I can't imagine it's not including both Los Angeles and one or multiple counties in the Bay Area. And if we can't get an adequate draw from those two counties, then we know that there's bigger issues.
So I would put that question out to staff. I mean, Stephen just said, I can't imagine it wouldn't include Los Angeles or the Bay Area. Is that true?
I don't think necessarily. I mean, if we think those are the right places to target, I think Judge Petru, you made a comment earlier that when you looked at the judges to bring on, there was some diversity with those counties. And, I think to me, more than saying it, well, from my perspective, more than saying those are necessarily both going to be involved in a pilot limitation, it's more that I think we would want to involve at least one sort of more concentrated urban, concentrated attorney area, right, one more rural, and then maybe something more mid-sized. I mean, I think if we're going to learn from this,
sure,
we need to see some of that kind of diversity. But to me, it's not necessarily, I'm not saying we should not do it, but I don't think it's necessarily true that we would definitely be LA and a Bay Area county. I would think one or the other would likely need to be included in.
Well, I mean, let's be blunt. I mean, Los Angeles eclipses the size of any county up here or elsewhere.
Right.
And
or all of them together. Yeah.
Yeah. And so I'd like to understand, like, from your point of view, Leah's point of view, does that, is your thought like we would have to include Los Angeles if we do a limitation on geographic scope?
From a numbers perspective, the answer is yes. From an everything else perspective, it's daunting, because I think for the reason that many things don't, we try not to pilot them there because it's so big and there's
right
so many different dynamics at play. So, but from a numbers perspective, yes, unless you were going to do many more Southern California counties like San Diego, San Bernardino, Riverside.
Right, those are big places.
Yeah, the Inland Empire and San Diego, then you might be able to get there.
So can I take a straw poll? Because I'm not sure we have consensus yet about whether or not we think we should roll out to all counties, but really concentrate on data collection in certain places, or if we think we should be limited to a certain number of counties. I think the latter is starting to lead, but I want to do a straw poll. So I'm just going to go to each person and see what you're thinking. You're not bound to this, but it's like a check-in right now to see how you are. So what do you think, Sharon?
You know, I'm still percolating on this, and
Okay.
what Leah said really resonated with me in terms of, you know, we want to make sure that we get enough paraprofessionals. That said, you know, coming from LA County, we really, in order to include LA County, we would really need some buy-in from like Sherry Carter and the court administrators, because there are many courts here. They don't all operate the same. And yeah, but like I can't see doing this without LA County.
Why?
From a sheer numbers and from a sheer pilot of rolling something out smoothly. How are we going to really find out unless we have a big messy county like LA County in the pilot? Like I think I'm all
You don't think,
for,
to push back, you don't think, for example, having San Diego and Riverside and, you know, up here, actually Alameda is bigger than San Francisco, but, you know, you don't think testing it out in places like Riverside would be adequate as far as size and complexity?
in terms of the factors that we're looking into, like consumer protection, like having enough paraprofessionals, tie into local self-help centers and legal aid organizations, I can't see, like, I don't think you're gonna get the valid data without LA County if they are on board. And this is the time to learn and to iterate. And I think that if we left LA County and then later did a full rollout, that's where you're going to learn the messy lessons. And I would rather learn the messy lessons now than later. But that's just my approach.
I'm going to jump in because we have half an hour left and I don't want us to get mired down on which counties yet. Okay. So Steve, I heard you say that you think it should be a limited number of counties. We haven't decided what number. Is that correct?
Yes, as long as that includes at least one rural area.
Okay. And then what do you think, Justice Petru?
I think that if we are going to have LA and a number of other places, I don't know why we don't just do the whole thing. And it could be that I don't understand. And so it could be, I'm very, very open to being persuaded by Leah and others that limiting it to LA and a few others will be much easier than just doing the whole state. But that's the argument I'd want to hear.
Okay, Julie, are you still thinking, or are you kind of formulating something?
I actually agree with Justice Petru. I don't see why we don't just open it up to the entire state. I don't see why we should have a program. I think it would lead to great confusion as to who can do what where if we only, limit it to certain counties.
Okay.
But I am also with her in that I can be persuaded by staff as to the practicalities of all of this.
And I'm going to go to staff after Fariba. Fariba?
Yeah, I'm also for the hybrid approach where we roll it out and then collect data from certain counties, certainly rural county, big counties, large counties, small counties. And I'm also open to having my mind change after I understand what's fully involved in doing a hybrid approach versus a limited approach.
Okay. So we're tasked with giving something to the working group on February 26th. I mean, maybe we only give them what we've got, but hopefully we can get to the location issue because also staff's going to need to have something written by the 19th. So I'm just going from how I can see you on the top of my screen. So going to staff, Leah, you've said what you've wanted to say, but do you want to add anything?
No, but I think we could be helpful in maybe making some recommendations that if we were going to do a limited geographic pilot, sort of trying to apply the criteria, although I'm not sure if you're going to go into a discussion on that next, Judge Yu, but okay, whatever criteria you all come up with, and just seeing if we could come up with a recommendation for a set of pilot counties for your next meeting.
Yes, I was thinking we could talk about criteria without talking about the name of the county, because that might make it less charged. But right now, I don't know that I have consensus that we only want certain counties. So I'm going to go to the next staff person on my screen, which is Christopher. Do you have any thoughts?
I was originally leaning towards limiting the geography, just as my personal perspective on it, because of limiting risk. But the more I've listened to this conversation, the more I kind of see the compelling reasons to maybe roll it out really broadly. So now I'm thinking less about limiting risk and more about, like, is there a cost associated, just a fiscal financial cost associated with rolling this out? Like, do you need on the ground county specific staff members or something, or some kind of infrastructure? And now I'm thinking more of, like, will that delay the implementation to do that, and how to make sure that the program is as close to financially sustainable as it can be in its formative years, even if its revenue model is loan-based in the beginning. So my position is now like right on the fence as a result of listening to this.
And those elements that you discussed, which are we going to talk about right now, once we go through everybody's thoughts, might help us actually get a little bit more off the fence. But Andrea, did you want to say anything?
Yes. Well, just quickly. So I can see both arguments. But I did want to respond to just the very question of what are we, why would we limit it? Kind of like, what are we getting out of that? And I think that first, I again don't assume LA County is going to be one of the counties. I'm not saying it shouldn't be, but I think we shouldn't assume it. I think we should talk about what the criteria would be if we do limit it. And I think what we would potentially get with a geographic limitation is potentially lower administration costs, less work and potential costs around whatever data feedback mechanisms are happening. And because it will be, I think by its nature, if it's more limited, more closely observed, I think it has the potential to limit some of the risk and allows us to learn from things that may be creating problems and change it on that smaller scale more easily than trying to change something we've kind of laid out statewide. I mean, it's such a big, complicated state. So I'm, again, not making a strong advocacy on the staff side or personal advocacy on this, except for to say, I think there is potential additional safeguards and data collection we can do in a focused way if it's limited. And I would agree with a couple comments that if we do limit geographic, I think it's important to have urban and rural representation, but again, not necessarily LA County versus another urban area.
Yeah, and if we keep, given what you said, Andrea, if we're keeping in mind that flexibility and feedback loop are important, it's easier to be flexible if you're not so huge, a Leviathan, right? And then also feedback loop, it's easier if there's fewer people on the feedback loop. So
yeah, there's a lot of momentum if it's statewide. And I guess there's good things to momentum, but I think it's harder to go back and unwind and say, actually, we're not going to do this whole, I'm making this up, but we're not doing divorce because we're really seeing this isn't working well in that space. This is, I mean, it's not impossible to change that statewide, but if you're changing it in 4 counties, after we learn from that, that's a very different scenario. It's a lot more nimble, I guess I would say.
Yeah. And Greg, what do you think?
Well, at the risk of repeating what a lot of other people have already said, I had come into this whole process assuming that it would be a geographical rollout, just for the reason that I was concerned about the state bar's ability to roll out the program fully to the entire state all at once, especially if the focus of the pilot is to improve things like the entry requirements and making sure that we're teaching the right things to these paraprofessionals to prepare them to provide competent legal services. If we rolled it out to the state, it could become overwhelming, I think, for the state bar to manage all that data coming in and also understand the data in some way that will make them be flexible and make changes to the program that we know are going to be effective. But that said, I mean, if we are saying, if the consensus is that LA County would have to be part of the initial rollout, then I concur that we might as well roll it out to the entire state at that point, because It is such a large part of the state, both from a population standpoint as well as the size of the court system there, and all the differences among the different courts within the county.
Okay, thanks. I think we lost Linda, and I don't know if Brady wants to say anything. Brady, do you want to say anything?
Sorry. Thanks, Erica. I'm listening mostly for the any legal red flags and to make sure I have the context if legal issues come up. But I don't think I have any insight to add on project design kind of policy calls.
Okay, thanks. But I didn't know if there was any legal implications that you wanted to share. So I wanted to check it to make sure.
No, not that I see. So thank you for checking.
Of course. So I think I still think we either are still processing this and we don't have clear consensus. So maybe in the time that we have, I want to just check in and see, should we still continue to go down this road on geographical area and location? Or do we want to start kind of putting more flesh to what we've already decided so that staff can write up their report? Yeah.
Yeah, for me, it would just be helpful to understand or maybe brainstorm for a minute about what additional information or insight would be useful to us in order to reach consensus on the geographical limitation question.
Okay, so we're thinking we should delve down and talk more about this in the 20 minutes that we have.
Well, I'm not saying we have to have a big conversation about it. I just would like to understand. So for example, we're all kind of sitting here going, maybe. So what information would be helpful to gather, which we're not going to do in the next 20 minutes, to help us move forward on that question? Is there information that we should be asking, Leah or Andrea or is there information we should be asking someone to gather to help us move forward on this question or not?
Okay, that's a good question. And Steve, you had your hand up.
I was gonna say, what's the money? What is it gonna cost if we do it statewide versus what would be the projected cost? I don't know if you guys from the state bar can give us those numbers, but giving us some kind of estimate about, based on the increased burden and the concerns, how much more are we adding to the cost of the pilot program if we roll it out in every county? Is that something that we can even get?
Yeah.
The cost and the revenue, right? The potential offsetting revenue, because we will charge a licensing fee.
Right.
Yeah.
Can we get that?
We can do our best. I mean, cost modeling is a deliverable for the overall effort. So we can certainly work on that for the pilot.
Would we be able to get that by the next meeting on the 16th?
We'll try.
Oh, okay, great, thanks. Any other factors that people want information on to help make the decision?
I would be curious to know, and maybe we could just kind of do a quick poll from the legal services community, just as one group of stakeholders, to get any quick feedback on if there's a strong feeling one way or another about geography, or a strong suggestion. Okay, if you do geography, like please pilot this kind of area or this county. That's just one group of stakeholders that I would personally be curious to hear what the feedback is.
And I'm going to go with something super simple that I'm sure Leah has. I have a good sense in my head for what are all the counties and kind of their general size, but if we could actually have a basic chart that shows us what are the counties in California, how big are they, like basic information like that would be useful to have in front of us when we're having these discussions.
I'm not sure we can find this. Oh, I see a hand up, and then I'll say what I would like to see. So Sharon?
So just wondering, and this is maybe like where we also talked to Bonnie Huff, out of all the counties, are there some counties that we identify that would just be particularly well suited for this because of local court support? Maybe they were part of Shriver programs in the past, so they know how to do a pilot, because we want this to be a success. And working within those jurisdictions that we think are going to be successful might be a factor to consider besides need.
Okay, thanks. Steve, did you want to say anything else, or is that old hand up? Okay, thanks. For me, I'm not sure if this is possible. I think maybe the Judicial Council would have some information, but I'd like to know about the sort of technology, like which courts have the ability to let people e-file, which and I think there is stuff that's out there, but which communities seem to have, you know, neighborhoods that have, or citizens that are able to have laptops or some access to technology or Wi-Fi, because I think they're given, well, I don't know when we're going to be able to start, but I think that technology in courts and access is really here to stay, because we've learned that that works. And so I think it would be helpful to know if there are pockets that have that might make it a little easier to implement for people. Any other thoughts about what we might want information, what information we might want to help us determine what factors we should look at when we're identifying the location? Okay, and if we can't get all this information by the next meeting on the 16th, I think I feel comfortable just giving a status report to the working group, if that's okay with our chair, that if we don't have a full on, you know, everything's buttoned down report, because we may not have all the data by the next meeting.
Yeah, that's fine.
Okay. Anything else before we leave the topic of location? Okay, so there were some other factors looking at this slide that include data collection. And one of the things that Andrea and Christopher and I were thinking is that we should probably talk a little bit about metrics and what we think might be some type of data collection or feedback loop. I don't know that we have the time to do that now. What do you think, Leah? We have about 15 minutes.
Yeah, I think maybe just a little bit of brainstorming about, as we've talked about it today, the idea I think is to use the pilot as a phased in implementation approach, as well as to gather information to help improve the program, or to, you know, be able to address shortcomings. So if you think about it from that perspective, what is the kind of data that we would want to collect to tell us, to help us do that, right? And I think a little bit of brainstorming on that, and then talking about the feasibility of that data.
Okay, I think that'll work in the time we have. And so just to start that off, remember when we talked to OshPod people and Bonnie, so they talked about client surveys or exit surveys, the just information about cost, all of those types of different things. So when we're looking at the feedback loop or information gathering, what is it that we would like to see obtained or gathered? Steve, you want to go first?
I was going to say, I think that's above my pay grade.
Oh, okay.
Trying to figure out the metrics of what we would need to see. I think I'm actually really going to expect to rely on the judiciary to report back how it's helping.
Okay.
Because that's going to be one source of data to get. And then I guess consumer surveys too.
Yeah. Sharon, I'm just going across my screen, so sorry if I'm going to some people first and others last.
I'd like to see rates of representation. So how many people are going to paraprofessionals? I would like to see consumer satisfaction surveys, or maybe focus groups or some other way to gauge that. I would like to, from a consumer protection standpoint, just look at how many rates of complaints come in. I would also like to get data, almost Kimberly's group. I like the fact that they just would pull random files sometimes, and if there's a way to do that. So randomized studies.
Like a random audit.
A random audit, exactly. And then talking to stakeholders. So getting feedback from court systems, self-help centers, legal aid organizations.
Okay, great. Julie?
All the criteria that have been stated so far sound good to me. I would just caution, over at the Department of Consumer Affairs, which is what Kimberly directs, those boards undergo an every 4-year sunset review process by the legislature, and the legislature makes them, each board, do a consumer survey, and it's based on people who have filed complaints, so let's say against doctors. The folks who answer those surveys are generally very unhappy. Well, first of all, they generally don't respond at all, so that they have a really low turnout. And those who do respond have had their complaint dismissed. And so it really skews the results. We have to kind of take it with a grain of salt.
Okay, or conceive of a survey that captures people when they're leaving the court process, as opposed to when they've stewed in it and they're really, there's just a lot of bitterness or something.
Right.
Yeah.
It's hard to do.
Yeah. And then Fariba?
I would like to get information about average rates charged. How long does representation take from beginning to end?
Okay.
And case types, based on case types. I like somehow to, as Steve mentioned, somehow to be able to collect information from consumers. Of course, self-help centers, like Sharon said, we will see usually when something goes wrong or it's a lopsided case. Now, lopsided cases now will be paraprofessionals and self-represented litigants, not just attorneys and self-represented litigants. And by the way, I just want to put this out there. At some point, I don't know where this belongs, but we've got to talk about the name of these new licensed legal support professionals. I'm not sure if I was talking to Amos earlier, so I'm not sure if we want to call it paraprofessional, because definitely it's not descriptive, and the average citizen, average user will not understand the role.
Okay, I'm making a note of that because that's
sorry to put one more thing on your plate.
That's okay. And then Justice Petru.
I really don't have any new area to add from what's already been discussed.
Great. I'm going to go the other direction now and ask staff. So Christopher, you're next on my little thing that I've got up there.
I think you've all covered it.
Okay. Greg?
Yeah, I think it's been adequately covered so far. I mean, I think from the judicial council standpoint, and maybe we can talk to Bonnie about this, what type of statistics we could get on speed of case handling by paraprofessionals as opposed to self-represented litigants. I agree with Fariba. If as much information as we can get, especially if there are not going to be caps on fees, on the types of fees that are being charged by county as well, and by type, would be helpful to know as well. The only thing I think I'd mentioned this before with random audits, we'd have to figure out how to design that, because there are some confidentiality issues there. We certainly can't just pull client files from a paraprofessional and look at how they handled the case.
Yeah.
So we would have to have a voluntary participation by clients, and what does that do to the data? I don't know. I mean, you'd have to have someone willing to share their experience with a paraprofessional, which may be more rosy than the average case, but we'll see.
Sharon, I see your hand, and I'll come to you as soon as I finish up staff, if that's okay. Leah?
I'm just thinking about, like, not every transaction or matter or service is going to come before the court. And some of the value of the paraprofessional may be to keep things out of court, writing letters to landlords, kind of dealing with, a visitation issue outside of court and getting it resolved. So I think we just have to be mindful of that everything isn't going to take place in a courtroom or in a courthouse, and we wouldn't want it to.
Yeah.
And I think the complaint number of actual complaints, I think Sharon mentioned that is an important one, because we don't really do customer satisfaction for attorneys. So I just, caution us not to hold the paraprofessionals to a standard we don't hold attorneys to.
Okay.
Yeah, absolutely. But I would just note that, for pilots like Shriver, attorneys, there was more of a robust evaluation, right? So the only other one comment I would make on this, a lot has been put out there that's helpful data points, is that I think the data and how robust it can be is also going to be tied to the geography question. So just, I think those are pretty closely connected questions in terms of how deep of a dive we can take.
Great, thank you, Andrea. And then Sharon, and then I have my thoughts too. Sharon?
It's more of a question for the group, and this actually builds off of Leah's comment. Are we trying to evaluate outcomes? For example, is access to justice a means to an end, or is it an end in of itself? And are we thinking that far when it comes to evaluation? Because how we determine that will also play into what we're evaluating.
That's interesting, because that sort of touches on what I would like us to maybe evaluate, which is compliance. Taking with a grain of salt that not everything is going to go into court. When we implemented the limited scope representation, right, that like Shariba was really involved with in the domestic violence world, we found that when we gave limited scope representation to alleged perpetrators, there was higher compliance with court orders. And so if you look at the understanding and compliance between a self-represented litigant and what happens in whatever proceeding that they're in, and then if there's a higher rate of compliance with a paraprofessional, that might be a useful piece of information. Or if it's exactly the same, maybe that's useful as well. So that's what I would add to the mix. We are really at 6 minutes. I think we've accomplished a lot. I wanted to check with Andrea, Leah, and Justice Petro and Christopher to see if there's anything else they want to talk about. And then I need like 2 minutes to sort of wrap things up.
Nothing from me.
Okay, Andrea?
I just wanted to share a quick piece of news. I was about to say personal, but sort of my personal professional news, just on next steps. And just let everyone know that I haven't had a chance to speak to yet, that I did just recently make the difficult decision to accept back my law firm pro bono counsel role at Morgan Lewis. I very much want to, support this process if I can as it moves forward, and we're coming up with sort of the staffing plan within the Office of Access and Inclusion. But I didn't want you guys to hear it from someone else, since we've all been working together on this, and I continue to hope to support the process in that new capacity. And we'll still be very much in the social justice, access to justice space, and hope to continue to partner with all of you in various capacities in that work.
Well, congratulations.
Yeah.
Yeah, and thank you, Andrea. It's been so, I think my background.
It's so nice.
It's been so great to work with you. You're just such a lovely person, and I'm really sorry to see you go, but I'm happy for you, and I know that it's a better thing for you, and you're still going to be able to do the work, and you're still committed to helping us if you can.
Well, you're so kind. It's been lovely to work with you as well. And absolutely, I'm not disappearing by any stretch, and in terms of this topic as well. So, but thank you. I assigned.
Thank you.
You're so sweet.
And then
for your service, Andrea, and you know that I'll be working with you no matter what.
Yes, we will continue to work together as we have over the years. So,
Andrea, Leah, did you want to say anything?
No, on this topic, just I
Closing.
shared with Andrea, I'm sad to see her go. But no, I don't have any other.
And to close us out, anything? No?
No.
Okay.
I agree, we made a lot of progress.
Yeah, it's been a lot of progress. Amazing work, everyone. So I know that staff will send us a reminder of our next date, and we'll send out the link, and I'm gonna just end it with Christopher, because he also deserves this huge thank you, because most of the work now will fall on him to memorialize what we've said, so that we can have a document to look at our February 16th meeting. So Christopher, anything you want to say to wrap things up?
I don't have anything to add. I think you all did a great job of figuring out what the next steps are for the next meeting.
So there was a lot of pre-meetings and pre-work. So thank you so much, Christopher, Andrea, Leah, and Justice Petru. A lot of help to get us to accomplish so much. So we'll see you on the 16th, and have a good, happy Chinese New Year, because that's on Friday the 12th. It'll be the year of the cow. And my husband's a cow, and cows are known to be very stubborn, and he fits the mold. So sorry, I don't offend if any of you are born in the year of the cow. So thank you.
Happy New Year.
Thank you.
Bye.
Goodbye,
Everybody.
everybody. Take care.
Bye. And thank you, Andrea.
Thank you.
I hope we talk soon.
We will. Thank you.
Bye, everyone.